What is your name and what state do you live in?
I'm Jeff Ransom, and I live in Washington State currently.
And where was your foreclosure?
They were both in New Jersey.
When did your foreclosure start and what was the outcome?
The first foreclosure started in approximately 2008. I bought about 6 years in court representing myself on the argument that they didn't transfer the note properly and they couldn't prove they were true party in interest. So I stalled for 6 years, and then they finally, the judge ruled in the plaintiff's favor in 2016, I believe.
And then
So
you also had a foreclosure on your homestead?
yeah, my primary home, that foreclosure, and it was initiated, I believe it was 2015. And I just lost that my primary residence last October, about a year ago from today, or from this month, this October.
Was New Jersey a judicial or a non-judicial state?
It's judicial.
Okay. Forged and facially invalid assignments and endorsements have been filed and used as a basis to foreclose in millions of cases. Please describe any that you or any expert investigator or witness found in your case.
I don't know. We didn't have any like forensic evaluation of documents, but what I did question was the authority of mortgage electronic registration systems to be able to have the authority to transfer and keep track of all transfers or ownerships of securitized debt instruments, the underlying mortgages for the mortgage-backed securities. So mortgage electronic registration systems validity has been challenged in other states and successfully challenged, I think, in Oregon. The courts basically listened to the argument, and I think it was Jeff Barnes that put forth that argument in that one. That's one of his claims to fame. But in my case, in my first case, the one I fought for 6 to 8 years, it was mortgage electronic registration systems that claimed to have transferred ownership of the note.
Okay.
And could not produce any actual transfer paperwork.
Entities foreclosing are representing themselves to be trustees for trusts, yet these trusts often no longer exist or have no capacity to demand foreclosure. You said, I think one of your foreclosures was in the name of mayors, so that probably wouldn't be the same kind of case, but.
No, it involved a securitized trust as well.
Okay, so what, if
Both.
anything, was there anything that indicated to you that the people that were claiming to be trustees for trusts were not actually trustees and that those trusts really didn't exist or had no
Oh
capacity
well,
or had no capacity to demand foreclosure?
yeah, there were inconsistencies in their pleadings that I pointed out, and especially in the second case where I hired a lawyer, he pointed out all the inconsistencies in their pleadings as far as the disposition of the note at every point in time. So he challenged all of those in court, and the judge didn't seem to even want to consider all that. Never even addressed it.
Did they give you any reason for why they weren't addressing that?
No, and my lawyer didn't press it either. He just presented the argument. He presented the complaint, and he did briefly touched on it in his oral argument, but it was a very brief oral argument, and he wasn't like pressing the argument really. He was leaving it up to the judge's discretion what he was going to consider and what he wasn't going to consider.
This sounds familiar. This seems to happen a lot. Now, did you ever get any evidence that I know you said that the entity foreclosing on you wasn't the party that was owed the debt? What kind of evidence did you get about that? And what was your experience in trying to get discovery in your case? That's
Stonewall. In both cases, the discovery was stonewalled by both plaintiffs. They claimed, oh, I have no right to be asking who, it's the current holder of the mortgage. That's not my business, none of my business. All I have to do is keep sending my payments. I'm not privy, they don't have to divulge the terms of the trust that the mortgage sits in. I don't have the right to ask them that. that was the point on both of my cases. They felt like it was just a stonewall, and the judge didn't. I mean, like I said, the first judge agreed with me, but it bought me at least 6 years, might have been more. But the second one, and this is with the courts closed, it sped through the court system in like a year. And I hired a lawyer for the second one. So that tells you at this point, they're just, pushing these things through. There's not even any consideration being given.
So
and you have to challenge. My lawyer said, okay, you can appeal it, pay me another $15,000 and we'll appeal it. I think you have a good case for appeal. I said, well, I don't like the way you presented the oral argument in the first case. I mean, so what are you appealing? What exactly are you appealing? You didn't even present, the arguments orally. I mean, he presented it in the paperwork, but in the oral argument when the judge was there, there was no pressing of his arguments at all.
So do you think there might be some kind of conspiracy or agreement among lawyers?
Well, like I was mentioning, New Jersey, I've been told, is a extremely bank-friendly state. So these things you have to go state by state. I know Florida is a lot more wide open. There's been a lot more they've gotten a lot more traction with these defenses. Let's put it that way. In Florida and in a couple other states, Oregon, like I said, Oregon, the judge or the courts ruled mortgage electronic registration systems as pretty much a sham. That's one state that's recognized that. And by the way, mortgage electronic registration systems, that was established by the banking industry. There was no law that was passed. There was no legislation underlying it. It was just something they got together and put together. And supposedly with 50 vice presidents, they're tracking the disposition of 60 million mortgages. So how do you do that with a staff of 50 people? You tell me. I'm in the IT business. How are you possibly going to track all those changes of ownerships and keep on top of it and make sure that it's, they're basically dodging or getting around the county recording offices across the country by doing this. So that way they don't have to take it into the county, pay the fee. They probably owe the county, millions of dollars in fees for bypassing the county recording. And if you go to the county, it shows up as mortgage electronic registration systems. It's the holder of the mortgage. That's so even the county must have been part of the, part of this whole thing, is my feeling.
Can you explain again, you were talking about how you realized that the title had never been transferred properly, and that's why the entities coming in to foreclose on you weren't owed the debt. Can you explain that a little bit more?
Well, the whole gist of my defense was prove that you're the holder of my mortgage by showing me transfer paperwork to that effect. Show me that you paid this entity this amount to purchase my note and make it part of your securitized trust. And the securitized trust, Garfield mentions this in his on his blog, that securitized trusts have very strict rules of which mortgages can, when they can enter. Are they performing or non-performing at the point they enter the securitized trust? In many cases, it's non-performing mortgages, and that breaks the rules of the trust. Because who would buy a security on a non-performing mortgage or a bunch of non-performing mortgages? So that would be another area of fraud for the investors in these securities to go after these folks.
And also, what about were there any backdated assignments in your case?
There were all kinds of irregularities in both cases of the assignments, the dates, the time the mortgage was admitted into the trust. All those things had holes in them, basically, but they were never considered by. I mean, the judge, based in the first case, let's see some transfer paperwork, but they can't force them to do it. There's no law that says they have to. So it has to be attacked at the legislative level, is my feeling. And good luck with that, because each state has its own you know,
Garfield talks about if you if you are compel the discovery and ask for sanctions for them not complying with discovery and that kind of thing, that you can end up either getting discovery or getting a very clear um, reason to object to any evidence that they put into the trial, I believe.
well, that all sounds really good, but again, you need a lawyer who's going to be like a bulldog
Right.
going back and forth after them to produce the discovery. And these lawyers, I mean, this guy who I hired, who's like one of the only foreclosure lawyers in the country doing these kind of cases that I know of. And Garfield has a short list of attorneys that get it as far as the defense. But Jeff Barnes is really like the only guy around doing it that I know of. And he was not aggressive in his defense at all. He presented the arguments, but then he didn't aggressively follow up on them. So maybe if you have a bulldog lawyer who's willing to put his reputation on the line, you know, to really go after it and fight hard for you, then maybe you could get some traction. But what my lawyer told me was you really have to this has to be settled in the federal courts. Basically, the federal courts are going to have to rule on this. So that means you got to take it up to the Supreme Court, and who's got the money to pay all the legal fees that would be involved in taking the case all the way to the Supreme Court. But that's what it's going to take.
Yeah, I know some people were successful in transferring their foreclosure case to the federal court. But anyway, let's get back to the due process violations, because in my mind, lawyers not actually doing their job and judges not doing their job is a due process violation. If there is some, there have been judges now that have been found to have taken money from the same banks that are foreclosing on people, and they don't reveal that ahead of time like they're supposed to.
The judge in my second case didn't even consider any of the arguments my lawyer presented. He didn't even consider them. He acted like the whole thing was a big joke.
Mm-hmm.
He was an Italian guy. Anyway, you can draw your own conclusion. Italian judge in New Jersey. Okay.
Yes.
I mean, this is the way the world works, unfortunately. And if you're going to really, try to get to the bottom of things, you need a big pot of money to try to do it.
Was there any other conflicting interest that the judge had in your case that they didn't report or that you know of?
Not that I know of, but I mean,
part of the mafia might be a big one.
I mean, well, yeah. I mean,
anyway,
listen, you see the president we just had, okay? So it shouldn't be that hard to think that kind of thing goes on.
Right. Now, did you ever go to the FBI or any other government agency to try to get help or consider joining any class actions or anything like that?
Well, a class action would be great, but it'd have to be everybody in New Jersey. It would have to be all New Jersey class action people, right? So
maybe
I did consider that, but hard to find 50 people in New Jersey who are all fighting the same thing. That's kind of a big ask to get that, to get that going. But maybe an organization like yours, if you get enough people, that could be a possibility, because now you have a network that's talking to each other.
Right. Thank you. Yeah, that's what we're hoping. All right. Well, thank you. I'm going to stop recording now.